Hello and welcome to the Beach House 34 podcast. I'm your host, Christine Worth. Welcome to our new subscribers and welcome back to our devoted listeners. If you're here, you know that I've covered the Darlie Routier trial transcripts from the very beginning. This is the mother who in 1997 was accused and convicted of murdering her two children in Rowlett, Texas. If you're brand new here and want to start at the very beginning, you'll find all of the trial transcript readings in their very own playlist on YouTube. Now, at this point, the actual trial testimony is over. Her sentence has been handed down, and now we move into the appeals process. After the appeals process, we'll hear the writ of habeas corpus, the statements from the writ, from both the prosecution and the defense, and some motions for DNA testing. And then finally, to wrap it all up, a few more related stories to kind of close it out. Currently, I have the 24th of September set as the day that we get back to true crime episodes. And many of you have actually reached out to me, and I appreciate this, and asked me to cover other trials. And I am looking into those. But in the meantime, as soon as something is decided, I'll just go ahead with the true crime episodes. But if I do decide on another trial, I will definitely let you know. With that said, let's begin this episode. Now, this one's going to be a little bit different from the others because normally I would read the entire thing through. But after I was a good hour recording this episode, just reading it directly through, I realized it really didn't make for very good listening because it's filled with legalese and references to other cases, which is actually one of the reasons why it took so long to get this episode out. And I apologize for that. I really had it all queued up and ready to go and then had some serious second thoughts about how, well, it could probably be a little bit more, I could probably add a little bit more to it than what was currently there. So in this episode, what I've done is you will hear the entire portion. I do not talk about the cases that it references in regard, similar cases like Texas versus, John Jones or something like that. I leave that out. I just leave in the actual content. But after each section, what I do is I give you a quick recap of that section in more of a plain language. In the show notes, if you're interested, I'll have a direct link to the document if you care to read through it yourself or even read along. So this first episode covers the first point of error that Darlie's attorney for her appeal, it's a different attorney, J. Stephen Cooper, it's one that he's filed. Okay, so much of the first point of error talks about how there was a conflict of interest regarding her trial defense attorney, Mr. Mulder. What Cooper makes reference to, though, in this portion of the appeal is the fact that because Mulder had represented Darin and there was a conflict of interest, Mulder wasn't able to bring up things that pointed to Darin as being the suspect in this case. But boy, her new attorney sure does. So with that said, let's begin. And the direct appeal starts like this. In the Court of Criminal Appeals of Texas, Darlie Lynn Routier, appellant, versus the state of Texas, appellee. And the appellant's brief is on appeal from the Criminal District Court number 3 of Dallas County, Texas, trial court number F96 39973-J. To the Honorable Judges of the Court of Criminal Appeals. Comes now Darlie Lynn Routier, appellant in the above styled and numbered cause, and files this, her appellate's brief, in support of her prayer that the judgment of conviction be reversed and the cause remanded for a new trial and, as appropriate, the court order further hearings in the trial court as requested herein. And then it goes on with the statement of the case. Appellant was indicted for the capital murder of a child under the age of 6. A jury found appellant guilty as charged. And by operation of the jury's answers to the 2 special issues, punishment was assessed at death. Next, there is a series of what they call points of error. in this document. And essentially, Darlie's defense team is pointing out legal issues or mistakes that they believe were made during the trial. Now, each of these points of error is meant to point these mistakes out that Darlie and her team believe warrants either a reversal of her conviction or a new trial. Now, the first point of error is Darlie's right to an effective assistance of counsel, also referred to as her Sixth Amendment right. It is believed this was violated because her attorney had a conflict of interest. They then go on to list a total of 14 points of error, but what we're going to do, we're going to take them one by one to make it easier. Now, in the document itself, they summarize each of these 14 points, and like I said, we're going to take them one by one. But after all of these are summarized in the documents, we then hear the statement of facts. Darlie Routier was charged with her 5-year-old son to death in the early morning hours of June 6th, 1996, in the downstairs quote-unquote Roman room of her own home. She was further accused of to death her 6-year-old son Devin in the same transaction, while her husband Darin and infant son Drake were asleep upstairs. Appellant's motive for these acts, as alleged by the state, was that she was quote-unquote angry over her family's purported economic difficulties and the negative effect this had on her quote-unquote lifestyle. Appellant's written and oral statements explained that she and her 2 older boys went to sleep in front of the big screen TV that summer's evening. Appellant had frequently slept downstairs recently because the baby's movement in the crib in her bedroom often woke up this young mother. Appellant said she was awakened during the night from the feeling of pressure on her shoulder and the sound of Damon saying, "Mommy." She then saw a male intruder walking away from her and then go through the kitchen, through the utility room, and out to the attached garage. Appellant followed this person initially, then turned on a light, and she saw a big knife on the floor, which she picked up and placed on the kitchen counter. She ultimately noticed blood all over the Roman room, saw her children injured, and noticed she too was bleeding. Appellant screamed for her husband, who soon came downstairs, and she called 911. The police investigation of the scene discovered in the garage an open window with a screen which had been cut, a variety of blood trails in the house, and microscopic fiber on the household's bread knife that was similar to the material from which the cut screen was made, and 4 spots of blood on appellant's nightshirt, which each had combinations of appellant's blood and of one or the other boys. The police also found a sock down an alley some 75 yards from appellant's house, which contained the blood of both Devin and Damon, but not appellant's. The police focused their investigation on appellant virtually from their arrival and weeks prior to any confirmed analysis of the blood evidence, and in doing so, all but ignored the reports from neighbors of a suspicious black car which had been seen in the area recently, including the night of the offense. The state's theory that the appellant's wounds were quote-unquote superficial, although this was a medical term simply meaning not deep. Actually, appellant's slashed throat was but 2 millimeters away from causing her death in 2 to 3 minutes' time. It is strongly urged that this court review the photographs of appellant's injuries. Such will reveal the same to be anything but superficial in non-medical language. Further specific evidence and testimony will be cited in support of the relevant points of error herein. And next is the summary of the arguments. The record fails to reflect appellant waived her constitutional right to conflict-free counsel after the state filed a motion alleging her lead counsel might have a conflict from his previous representation of appellant's husband. A significant portion of the reporter's record was lost or destroyed, thus requiring a reversal of the conviction. Additionally, appellant is entitled to a new trial because the reporter's record fails to conform with the law and cannot be corrected, or, alternatively, appellant is entitled to a hearing on her challenges to the record. The trial court's refusal because of a violation of quote-unquote the rule to permit appellant's investigator to testify as to what the state's bloodstain expert told the investigator and defense attorneys violated the applicable rule and due process. The trial court excused a sworn juror in violation of the rules and Constitution. The trial court also violated the rules and constitutions in addressing and answering a jury question during deliberations outside appellant's presence. Lastly, the trial court erred in refusing to act on a formal bill of exception filed by appellant. So, before we get into the first point of error in this, let's just summarize right now what we've learned so far, because there's a lot of details in this document. So essentially, as we all well know, Darlie was charged with murdering her two older sons, ages 5 and 6, in their home on June the 6th of 1996. Now, the prosecution alleged that she committed these acts due to anger over the financial issues that her family was having. Darlie's account was that she fell asleep downstairs with her boys. She woke up to pressure on her shoulder and then her son saying, "Mommy." She saw an intruder leaving and followed this person, found a knife. She noticed blood. She called 911. Additionally, the key evidence was the cut window screen in the garage, the blood trails in the house, the fibers on a knife matching the screen material, blood spots, eventually, and we'll get to these in other points, on her shirt from both her and the boys, and the bloody sock that was found 75 yards from the house. The prosecution argued that Darlie's wounds were superficial, though medically, this is the medical term, and it essentially means not deep, but her throat wound was close to being fatal. So after she was convicted by the jury and then ultimately sentenced, several issues are brought up in this appeal that her attorneys believe need to be looked at again. One of them is the potential conflict of interest. There's no record that she waived her right to a conflict-free counsel after she stated concerns about her lawyer basically had previously represented her husband. We'll get into this. There were some lost court records. Significant portions of the court record were either lost or completely destroyed. As far as talking about the record, the accuracy of the record, the claims that the court record does not meet the legal requirements. The court didn't allow Darlie's investigator to testify about statements that contradicted the state's blood expert when he was on the stand. A juror was dismissed because they allegedly violated the rules and constitutional rights, and this again will be discussed later on. These are just all the different points that they're bringing up at the beginning. The jury question handling. The court evidently answered a jury question that they had during deliberations, and Darlie was not present when this occurred. The court also didn't act on a formal bill of exception that was filed by Darlie. So all of these points that they're going to bring up in this appeal will be discussed in depth, but they're just right now kind of giving just a 30-foot view, right? So anyway, let's move on to point of error number 1. Appellant's Sixth Amendment right to effective assistance of counsel was violated because her lead counsel had an actual conflict of interest, and the trial court did not conduct a hearing on the state's motion to determine whether he should be disqualified. And here are the statement of facts. Appellant's lead counsel represented her husband at a hearing that was substantially related to the facts of her case when her husband was a prosecution witness and a suspect. Appellant was initially represented by court-appointed counsel because she could not afford to retain a lawyer. On September 19th, 1996, the state filed a motion to discharge her court-appointed attorneys because she was no longer indignant. The state's motion alleged that Douglas Mulder, quote, one of the most successful attorneys in the state of Texas, unquote, had informed the trial court on September 12th, 1996, that he was retained to represent appellant. Appellant's court-appointed lawyers appeared as her counsel of record, And Mulder was present in the courtroom on September 20th, 1996, when the trial court conducted a show cause hearing to determine whether her husband, Darin Routier, and her mother, Darlie Key, should be held in contempt for violating a gag order. At the beginning of the hearing, Mulder announced, quote, "I am retained by Miss Key to represent her, and she has asked me to represent Darin as well. I didn't know that until this morning," unquote. Mulder informed the trial court that he asked one of appellant's attorneys to represent Darin, but the attorney told him that he could not do so. Darin Routier was accused of violating a gag order which prohibited any witness or prospective witness from furnishing, quote, "any statement or information which could reasonably be expected to be disseminated by means of public communication," unquote, about the following subjects. 1. The expected testimony of the defendant or any witness. 2. The character, reputation, or credibility of a witness. 3. The contents of any statement given by the defendant. And 4. The nature of the evidence which may be presented. Darin Routier was a witness and a prospective witness because he had testified about the facts of the case at a bond hearing and received a subpoena to testify for the state at the trial. The show cause order alleged that Darin Routier provided unspecified, quote, "statements and information about appellant's case" to the KRLD radio talk show hosted by Rick Roberts, which was aired on July 26, 1996, after he received his subpoena. On the day after the talk show was broadcast, a Dallas newspaper published a story which stated, quote, "prosecutors and police reacted angrily yesterday after the mother and husband of Darlie Routier appeared on a radio talk show to contend that Routier is innocent of charges that she fatally her two children. Assistant District Attorney Greg Davis filed a notice that Darlie Key and Darin Routier had violated a court gag order and asked District Judge Mark Toll to schedule a hearing to consider sanctions against them," unquote. The article also stated that Rowlett Police Chief Randall Posey was, quote, "outraged that the Routiers would so directly violate Judge Toll's court order," unquote. When the state introduced a tape recording of the Rick Roberts talk show at the hearing, Mulder assured the trial court that he had already reviewed it. Mulder did not introduce any evidence or call Darin as a witness. Without placing him under oath, the trial court asked Darin whether he knew that the gag order pertained to him, but it did not question him about what he said to the media. Darin acknowledged that he received a subpoena to testify for the prosecution, but he claimed that he was not aware that the gag order applied to him. Mulder argued that Darin Routier did not violate the gag order by appearing on the talk show because, quote, "as I understand it, he did not discuss the evidence or really anything that pertained to the case," unquote. The trial court reluctantly agreed with Mulder. Quote, "Well, I have heard what Mr. Routier stated on the show. I listened to those tapes several times. You did not go into any of the facts of the case. You were under the gag order, but since you did not go into any facts in the case, the court at this time is unable to hold you in contempt," unquote. So let's just kind of summarize really quick what we've learned under the statement of facts under this point of error number 1. So we learned that Darlie, as we know, initially had a court-appointed attorney because at the time she couldn't afford her own. But in September of 1996, the state said that she was no longer indignant for free lawyers. And so Douglas Mulder, a Texas attorney, was now going to represent her. So on September 20th of 1996, there was this hearing about whether or not Darlie's husband, Darin, and Darlie's mom, Darlie Key, had broken a gag order by talking about this case publicly on a radio talk show. At this particular hearing, Mulder said that he was representing both Darlie's mom and Darin, even though he was supposed to be Darlie's lawyer. Now, this gag order, this whole hearing on this gag order, it was supposed to stop people, witnesses, from talking publicly about expected testimony. Now, Darin, he was accused of talking on this radio show, right, about Darlie's case in July of 1996. People were rightly upset. But at this hearing, Mulder, the attorney for Darin at the time, and evidently now Darlie, he reviewed the evidence and he argued to the judge that, hey, Darin didn't really violate this gag order because he didn't actually talk about specific case details. The judge actually went ahead and agreed with Mulder, did not punish Darin for this potential gag order violation. And that's where we then end this summary and then we move on. Now, we're still under the point of error, number one, but now we're going to go into the lead counsel's third party fee arrangement. When the show cause hearing was completed, the trial court asked Darin Routier whether he had retained Mulder to represent appellant at her trial. Darin denied this. The trial court then asked Darin whether appellant had arranged to have Mulder represent her at her trial. Darin responded that he did not know of such an arrangement, but he added, quote, "I don't understand exactly what he has met with her," unquote. The trial court repeated the question, and Darin unequivocally denied that appellant had made any arrangements to have Mulder represent her. Mulder attempted to clarify his role in the case by informing the trial court that Darlie Key, retained him as a consultant to assist appellant's court-appointed lawyers. The trial court ruled that Mulder could act as a consultant to her appointed counsel and remain in the courtroom during the trial, but he could not file motions or directly participate in the litigation of the case. The trial court advised Mulder that he had to file a formal motion to substitute himself as counsel of record before he could take control of the defense. Okay, so in this little piece that they're talking about, after the gag order hearing, the judge asked Darin Routier if he had hired Douglas Mulder to represent Darlie at her trial. He said no, he didn't. The judge then asked if Darlie herself had arranged for Mulder to represent her. Darin said he didn't know of any such arrangement, though he did say that he mentioned Mulder had met with Darlie. When Darin was asked again, he firmly denied that Darlie had made any arrangements at all with Mulder. Mulder then explained that Darlie's mom, Darlie Key, had hired him as a consultant to help Darlie's court-appointed lawyers. So what happened then is that the judge ruled that, yes, Mulder could act as a consultant. He could be in the courtroom during the trial, but he couldn't file any motions or even directly participate in the case. The judge then further said, hey, Mulder, if you want to take over Darlie's defense, you're going to need to file a formal motion to become her official lawyer of record. So that's kind of where we're at in this particular section of the appeal called the lead counsel's third-party fee arrangement. So next, we're going to move on to the uncertified record of the hearing on the motion to substitute the counsel. Mulder filed a written motion to substitute himself and his associates as appellant's counsel of record on October 21st, 1996, which was the first day of jury selection. The trial court's entry on docket sheet for that date stated, quote, "Hearing on attorney Douglas Mulder's motion to substitute counsel. Testimony and evidence received. Motion granted. Douglas Mulder and associates substituted as defendant's attorneys in this case," unquote. There is no certified reporter's record of the proceedings on the morning of October 21st, 1996. The proceedings were stenographically transcribed by the court reporter who filed the original record in this case, Sandra Halsey. But the trial court found that Halsey's entire record had to be replaced with a new record because it did not conform to what happened at the trial. The court reporter who prepared the new record, Susan Simmons, included a 54-page uncertified English translation of Halsey's paper stenographic notes of the proceedings on the morning of October 21st, 1996, in Volume 10 of the new record. Simmons signed a certificate in that volume, but it expressly states that Simmons did not certify that those pages were a true and correct transcription of what happened in court. Mulder's prior representation of Darin Routier at the show cause hearing was not mentioned in the uncertified English translation of Halsey's stenographic record of the proceedings on the morning of October 21st, 1996. The uncertified pages did contain a brief discussion of a separate conflict of interest arising from Mulder's representation of appellant's mother, Darlie Key. According to Halsey's uncertified stenographic notes, when Mulder presented his motion to substitute himself as appellant's attorney of record, the trial court asked Mulder whether his, quote, arrangement as a consultant, unquote, with Key, meaning Darlie Key, Darlie's mother, was terminated. Mulder responded that it was, quote unquote, expanded to include representation of appellant during the trial. The trial court asked appellant whether she wanted Mulder to represent her, and appellant stated that she did. The trial court then asked appellant, quote, if there is any potential conflict with Mr. Mulder representing you and being a consultant to Ms. Key, do you waive any potential conflict that might exist? And she responds, I'm not sure if I understand. And Mr. Mulder then says he wants to know if you give up any claim to a conflict insofar as I represent your mother as a consultant. And the defendant says, no, there is no conflict. And the court says, so you waive any conflict that might exist. Is that correct? And the defendant says, yes, sir. The trial court granted Mulder's motion to substitute himself and his associates as appellant's counsel of record and discharged her court-appointed attorneys after that colloquy was completed. Okay, so let's just, kind of go over what we've learned in this particular section. So what happened is on October 21st of 1996, which also happened to be the first day of jury selection, Douglas Mulder, Darlie's attorney, filed a motion to become her official lawyer. And on that day, her court-appointed attorneys were released, and she now had a new attorney, this Douglas Mulder. And remember, this is the first day of jury selection. The court records show that this was granted after a hearing where, evidence was given as to, hey, this is okay. The thing is, though, is that there is no official certified record of this hearing. The original court reporter, Sandra Halsey, her record was found to be inaccurate and had to be replaced. The new court reporter that kind of stepped in to kind of fix up what Halsey had not quite done, her name was Susan Simmons. She included an uncertified 54-page translation of Halsey's notes in the new record, but it wasn't certified. So the way that I get this is that because it's not certified, they can't use it as like an official court transcript or what have you. Even these uncertified notes that this second reporter, Susan Simmons, did don't even mention Mulder's previous representation of Darin Routier. However, they do show that there is a discussion about a potential conflict of interest because Mulder had been consulting for Darlie's mom, Darlie Key. And when Mulder was asked, if this arrangement with Darlie herself, conflicted or was going to be an issue or if he was going to release himself from the duties of representing or being a consultant to Darlie's mom, Darlie Key, he instead said that his arrangement was expanded to include representing Darlie. So the judge then asked Darlie if she understood, and initially she said no, she didn't quite get what they were asking, so Mulder explained it to her, and then Darlie said that there was no conflict and agreed to waive any conflict that might come up in the future. So after this, the judge then granted Mulder's motion to become Darlie's lawyer and then dismissed her court-appointed attorneys. So There is also in this document a citation here, which is important. And here is what the citation says. Simmons refused to certify that Halsey's paper stenographic notes were a true and correct record of what happened in the courtroom because Simmons did not trust Halsey's work, and Halsey lost, destroyed, or concealed the audio tape of the proceedings that she made on the morning of October 21st, 1996. Now, after the original reporter's record was filed in this case, there were 28 hearings in the trial court, which resulted from this court's orders for the trial court to ensure the accuracy of the record. This supplemental reporter's record will be cited as, and then it gives a volume number and a page. The first hearing was styled as a quote unquote solo volume without a number, but it is cited as SRR.1. So essentially, this new stenographer, Simmons, refused to certify Halsey's paper stenographic notes as being accurate because Halsey's work was not trusted. Obviously, it was lost, destroyed, or this audio recording was lost or destroyed, or it was hidden. And this is just in reference to the morning of October 21st, 1996. After the original court transcript was filed, there were actually 28 additional hearings in the trial court, and these hearings were ordered by the appeals court to check the accuracy of the record. So the next section, and we are still underneath the point of error number 1 in the filed appeal, and the next section is the state's motion to determine whether appellant's lead counsel had a conflict of interest. On November 12th, 1996, the state filed a motion that was styled Notice of Possible Conflict of Interest. The state's motion asked the trial court to determine whether Mulder had an actual conflict of interest because of his prior representation of Darin Routier at the show cause hearing, and if so, whether appellant and Darin Routier would waive it. The state's motion alleged that Mulder knew when he represented Darin Routier that the state disbelieved and intended to disprove the defendant's claim that these murders were committed by an unknown intruder. Mr. Mulder knew that the only other adult person in the residence during and immediately after these murders was his other client, Darin Routier. Mr. Mulder knew that the state's investigation was ongoing with regards to the analysis of physical evidence. Recent analysis of physical evidence suggests that Darin Routier may have participated with the defendant in the crime or cover-up of the crime. The state disclosed 2 new pieces of circumstantial evidence that connected Darin to the murder of his sons and linked them to the of appellant. A white tube sock that was found in the alley behind the Routier house had the blood of both children, a faint trace of appellant's DNA, and fibers from Darin's sneakers on it. There was also a head hair on the knife that inflicted the children's wounds, and appellant's wounds, which matched a known sample of Darin's head hair, the evidence of Darin Routier's guilt that the trial court was aware of. The trial court was aware of the significance of the new evidence that connected Darin Routier to the murder weapon and sock because the state presented a preview of its case at a bond hearing. The record of that hearing and the trial contains a substantial amount of other circumstantial evidence, which also tended to incriminate Darin Routier. Darin Routier had a powerful pecuniary motive to kill appellant. Darin's business was failing, and he was deeply in debt. Appellant's life was insured for $250,000. Appellant suffered multiple knife wounds during the offense, and Darin was totally unharmed. Dr. Vincent DeMaio testified that appellant could not have inflicted her own wounds, and she had to stab herself with both hands to do so. A significant part of Darin's description of what happened on the night of the murder was implausible and inconsistent with appellant's version. Darin was in the bedroom on the second floor, and appellant was on the first floor with their sons. Damon and Devin, when the children and appellant were. Darin testified at a pretrial hearing that he was awakened by the sound of glass breaking and appellant screaming. Darin and appellant agreed in their written statements that Darin ran down the stairs and went straight to the room where the boys were attacked. Appellant told the police that Darin yelled, "What is it? What is it?" And she responded, "He cut them. He tried to kill me, my neck." At the bond hearing, Darin acknowledged that he saw appellant standing at the foot of the stairs when he came out of the bedroom. Appellant's throat was cut and her white nightshirt was drenched in blood, but Darin claimed in his written statement that he ran past appellant to the room where the boys were killed without noticing that she was injured. Darin Routier made suspiciously inconsistent statements about his blue jeans. At the hospital, early after the attacks, the police noticed blood on his blue jeans and a tear just below the right knee. When asked about the tear, he said he got it while working on the backyard gate just the day before. According to the police report, he didn't explain how blood got on his jeans because he said he came down the stairs naked and got blood on his stomach and bare knees while trying to give CPR to Devin. In his written statement, Darin told the police that he went to sleep naked, rushed downstairs nude when he heard appellant scream, and then went back upstairs to put his pants on after he gave first aid to the children. At the bond hearing, Darin claimed that he went to sleep nude and took the time to put his jeans on before he rushed downstairs to find out why appellant was screaming. Several eyewitnesses saw Darin Routier remain at the crime scene for an inordinate amount of time after appellant was rushed to the hospital. Officer Matt Walling noticed that Darin was sitting on the curb near the house after the ambulance left. Walling asked Darin whether he had a way to get to the hospital, and Darin told him that he did not. One of Darin's neighbors assured Walling that he would drive Darin to the hospital. 30 minutes later, Walling noticed that Darin was still at the crime scene. Walling told him that he had to go to the hospital, and he finally left. A neighbor, Nelda Watts, and you'll remember her, she was the retired school teacher who lived across the street from the Routiers. Nelda said that she saw Darin lingering at the crime scene when his wounded wife and dead children were at the hospital. Watts thought that it was strange that Darin did not leave. She told the police that she believed that Darin and appellant were both involved in the capital murder. Another neighbor, Bill Gorsuch, also saw Darin lingering at the crime scene, and Gorsuch thought that it was very strange that Darin did not appear to be upset. When the surgeons were operating on appellant at the hospital, Detective Patterson noticed that Darin, quote, acted as if nothing serious had happened. Darin, quote, smiled and laughed and boasted to the detective about the size of appellant's breasts. Appellant's statements to the police did not conclusively exonerate her husband. Appellant stated that she only had a brief glimpse of her assailant in the dim light that emanated from a large screen television a moment after she regained consciousness. Appellant was initially uncertain about the intruder's race, and she did not see his face. Her description of a white male with long hair in blue jeans fit Darin as far as it went. Darin wore blue jeans that night, and he had his hair in a ponytail at the hospital. Okay, so this is interesting, right? Um, let's kind of summarize this a little bit. We know, I mean, as far as like, if you're thinking a motive, right? Darin had a motive. Darin was in debt. His business was failing. Darlie had a $250,000 life insurance policy. Darlie had multiple knife wounds. Darin was completely unharmed. And an expert, Dr. DeMaio, said that there's no way that Darlie could have inflicted her own wounds. You know, she'd have to use both hands. There are inconsistent statements in, at least regarding Darin. Now, Darin's story about what happened the night of the murders doesn't match Darlie's. He gave conflicting statements about whether he was wearing jeans or whether he was completely nude when he came downstairs. And he made inconsistent statements about how his jeans got torn at the knee and how come blood was on them. Some people, and I did not know this, but evidently after the crimes had occurred and everybody had been, carted off to the hospitals, Darin lingered around at the crime scene for a long time. We know that he tried evidently to get into the ambulance, but the paramedics would not let him in the ambulance with Darlie, which kind of struck me as weird. I mean, wouldn't you be more concerned about your kids? I mean, why did he want to jump in with Darlie? And why was he so emphatic to jump in with Darlie? I mean, I understand that there's like three people you care about that are all being taken care of individually. So, my God, who do you choose, right? I mean, it's uh, a horrible, horrible situation to be put in. But still, I mean, yeah, the kids. Wouldn't you be worried about the kids? But anyway, that's just, again, my personal opinion and just me. So after the crime and after everybody had been taken away, the even neighbors found Darin's behavior kind of strange. They didn't think that he seemed to be upset enough. At the hospital, he acted pretty casual, according to some officers, even joking about Darlie's breast size while she was in surgery. We've talked about this before in the past. I still don't get this. I think it's very demeaning to do that, but nonetheless. And as far as the physical evidence goes, the sock that was found down the alley that had the children's bloods, it had just a faint trace of Darlie's DNA on it, but fibers from Darin's sneakers were found. And even a hair that matched Darin's was found on the murder weapon. Now, Darlie's statement was that, at least about the attacker, was really vague. And we all know this, right? But it could potentially fit Darin, a male with long hair in blue jeans. So essentially, what they're saying here in this appeal portion is that the evidence does suggest that Darin might have been involved either in the murders themselves or in their cover up. So, and again, this, right, raises questions about potential conflicts of interest for Darlie's lawyer who had represented Darin. Now, in this section, there is a citation, and most of these citations really just deal with document numbers and case numbers or something like that. But some of them have some pretty good information, and this one is one of them. In this citation, it's citation number 5. It says, the sock was probably the most important piece of evidence at the trial. The prosecutor contended that appellant took the sock out of the house because for it to be found in the house would somehow incriminate her. Appellant's attorneys argued that she could not have carried the sock with the blood of both children on it out of the house to the place where it was found because there was substantial circumstantial evidence that she sustained deep knife wounds which bled profusely before either boy was cut. There was no blood between the house and the location where the sock was found, and she did not have enough time to carry it from the house to that location after the children were and then inflict her own wounds. So in essence, this sock is a really kind of a crucial piece of evidence. They didn't really talk about it a whole lot in the trial, but the prosecutor claimed that the defendant, appellant Darlie, took the sock out of the house and somehow got it down the alley, and she got back in and she was the one that put the sock there. Now, the defense says that she couldn't have possibly carried the sock out of the house. And the reasons were because, she at this point would have been badly cut and bleeding before either child was hurt. And no blood was found between the house and where the sock was discovered. And there wasn't enough time for Darlie to commit the crime, take the sock to where it was found, and then injure herself. So that was this piece. The next piece, under the point of error number 1, we're still under number 1, is the trial court's unfulfilled promises to conduct a hearing to determine whether appellant's lead counsel had a conflict of interest. On November 12th, 1996, the same day that the state's notice of possible conflict of interest motion was filed, the trial court conducted the following colloquy with appellant and two of the prosecutors. The court: all right, let's put on the record. I have in my possession notice of motion, notice of possible conflict of interest by Gregory Davis, an assistant district attorney from Dallas, asking me to ascertain whether or not Mr. Mulder has any conflict of interest in this case. And I believe that the record will reflect that I have already asked these same questions of Mr. Mulder when we first started, and that Mrs. Routier previously waived any conflict of interest. Is that not so, Miss Routier? And the defendant says, yes, yes, sir. And the court says, and I believe that your husband, Darin Routier, also knowingly and intentionally waived any conflict of interest? And the defendant, yes, he did. And the court says, I think that was all in the record, was it not? The defendant says, it was asked to us at the beginning when we changed. And the court says, that is my recollection of things. The defendant says, yes, sir. And the court says, we did that the first day here, didn't we? Mr. Toby Shook says, I think so. And the defendant says, we did it that day, but you had asked me when I was changing attorneys. And the court says, yes, ma'am, but I mean in Kerrville. We did it right then and there? The defendant says, yes. The court says, as I recall it, it was the first day before the jury, change of venue and all that, before we got into the jury selection. Miss Sherry Wallace, and again, this is all quoted in this direct appeal, and she is a part of the prosecution. Judge, I think this is new evidence, and Greg just wanted to make real sure. This is some new evidence. And the court says, well, I will tell you what we'll do. We will have the hearing when this jury's picked. We will have a hearing all over, and I will ask Miss Routier again. And I will ask Mr. Routier again. I'm sure we will see what the questions are. And the defendant, Darlie, says, I know you will have to go through that procedure, but the questions will be, and the court says, well, I feel I will not be surprised at the same answers. Thank you. But we will do it after we get this jury picked. And the defendant says, yes, sir. And the court says, all right. On November 18th, 1996, the trial court briefly addressed the state's motion to determine whether Mulder had a conflict of interest because of his representation of Darin Routier, again, without ruling on it. The court. Now, I have several motions. I have a motion filed last week considering any conflict of interest that Mr. Mulder might have. The Routiers, I think, we have already waived that. We have got him on the record when they came down here the first day, was it not, Mrs. Halsey? And she is the court reporter, and she responds with, yes, sir. And the court says, on the 21st, as I recall, I put Miss Key under oath, Mr. Routier under oath, Miss Darlie Routier, the defendant, under oath for this purpose only. And they both waived any conflicts that may exist. Has anything new happened since then? Mr. Mosty says our response that Darlie Routier signed last week further reconfirms that. And the court says, that's right. She reconfirmed it last week. Now, we can have a brief hearing when we start this on the 6th, if everybody wants to, but I'm quite sure the answers will be the same. The signed quote-unquote response that defense counsel Mosty referred to is not in the record. Despite this second promise to conduct a hearing on the state's conflict motion, such is never mentioned again in the appellate record of the trial. Okay, so in this part, we learned that on November 12th of 1996, the court had, discussed a motion that was filed by the prosecution about a possible conflict of interest for Darlie's lawyer, Douglas Mulder. The judge had said that he had already asked Darlie about this when Mulder first became her lawyer, and that both Darlie and Darin had waived any conflict of interest. And Darlie confirms this, saying that, yes, it happened when she changed attorneys. But another prosecutor, Sherry Wallace, she happened to mention that there was new evidence suggesting that they needed to reconfirm this. I don't know what this new evidence was, but subsequently what happened is the judge then promised, hey, we'll go ahead and have another hearing on this after we select our jury. And then at that point, he would then ask Darlie again about this potential conflict with her attorney. On November 18th, the judge brought this issue up again. And he recalled that Darlie, Darin, Darlie's mom, they had all waived these conflicts under oath back in October. But with all of this new stuff, evidently, that the prosecution had come up with, the judge says, okay, well, I agree to and promise to have a brief hearing about this on the 6th if he needed to, although he expected the answers would be the same. And despite saying this, to hold this hearing about this potential conflict of interest, at least again, there's no such record of this hearing ever taking place whatsoever. Next, we move on to the argument and authorities. And there's a small paragraph, and then there's a section that says the trial court violated its constitutional duty to conduct a hearing on the state's motion to determine whether appellant's lead counsel had a conflict of interest. Argument and authorities. Appellant's Sixth Amendment right to effective assistance of counsel was violated because her trial court did not conduct a hearing on the state's motion to determine whether her lead attorney, Doug Mulder, had a conflict of interest. There is no reason to remand the case for such a hearing now because the record clearly shows that Mulder had an actual conflict of interest and prejudice must be presumed. The Sixth Amendment guarantee of effective assistance of counsel cannot be satisfied, quote, when the advocate's conflicting obligations have effectively sealed his lips on crucial matters, unquote. An actual conflict of interest existed if counsel's duties of loyalty or confidentiality to the defendant and another client were inherently opposed to each other. A trial court confronted with and alerted to possible conflicts of interest must take adequate steps to ascertain whether the conflicts warrant a substitution of counsel. There are 3 circumstances in which the trial court must conduct a hearing to determine whether counsel should be disqualified. And number 1 is the attorney or the defendant made a timely objection to a potential conflict of interest. Number 2, the prosecutor raised the issue and the, quote, facts demonstrate convincingly the duty of the court to recognize the possibility of a disqualifying conflict of interest, unquote, or number 3, the trial court, quote, knows or reasonably should know that a particular conflict exists, unquote, in spite of the fact that neither party raised the issue. The state's motion to determine whether Mulder had a conflict of interest because of his representation of Darin Routier was certainly sufficient to trigger a constitutionally mandatory hearing. The potential for a conflict existed for 3 reasons. First, Darin Routier was suspected of participating in the crime that appellant was accused of. Second, Darin was an important prosecution witness. And third, there was substantial relationship between Mulder's representation of Darin and appellant. The need for a hearing was so obvious that the trial court, quote, reminded the defense that it had inquired into a possible conflict several weeks, unquote, before the state raised the issue. The trial court did not perform its constitutional duty to conduct a hearing about the conflict that arose from Mulder's representation of appellant's husband, regardless of whether the uncertified English translation of Halsey's, this is the person who took the notes in the trial, Halsey's stenographic notes of the proceedings on the morning of October 21st, 1996, can now be considered as part of the record. The uncertified record of those proceedings shows that the trial court only conducted a hearing about the potential conflict that existed because of the Mulder's representation of appellant's mother, Darlie Key. The separate conflict that existed because of Mulder's representation of Darin Routier was not mentioned in the uncertified part of the record, and the trial court did not keep its promise to conduct a hearing about that conflict after the state raised the issue. So here, we're kind of continuing the same argument in here. There's just, different portions of it. But essentially, in this particular section, it's the main claim is that Darlie's right to effective legal representation was violated. And this violation happened because the court never held a hearing to determine if Doug Mulder, her lawyer, had a conflict of interest, despite the prosecution saying, "Hey, we might have some, new evidence here." And evidently, the court is supposed to it must hold a hearing if the lawyer or defendant objects to this potential conflict, which is what happened with in regards to the prosecution. The prosecutor raised an issue that said, "Hey, we have information," and the court knows or should know about this conflict. So, and this potential conflict is, I'm still kind of foggy about all of this, but the prosecution, I know we've said this like so many times. The prosecution has some kind of information. We don't know what it is, at least at this point. I don't know if we'll ever know. But they did bring this up. Darin is suspected of being involved in the crime and was a witness for the prosecution. And the fact that Mulder represented Darin, who's obviously very, very close to this case, right? With Darlie being his wife, that there should have been another hearing, but there wasn't. And then they talk about the stenographic notes of Halsey, the court reporter at the time, and these were brought up about the potential conflict of interest and how Darlie waived it. This evidently all happened on the morning of October 21st of 1996. And this was one where the recordings or the audio or whatever was lost or something happened to it, and this was due to Halsey. So they had somebody named Simmons come in to kind of go over these written notes to try and make sense of them. So they didn't have anything to fall back on. So nonetheless, I mean, this is just kind of a rehash a little bit of what we've already heard. And the next section that we get into is the appellant's conviction must be reversed because the trial court should have known that her lead counsel had an actual conflict of interest when it failed to conduct a constitutionally mandatory hearing on the matter. When the trial court violated its constitutional duty to inquire about counsel's conflict of interest, the defendant is entitled to relief, regardless of whether the conflict adversely affected her attorney's performance. If, as occurred here, a trial court should have known that counsel had an actual conflict of interest and failed to conduct a hearing when the state raised the issue, the defendant's conviction must be reversed automatically. A post conviction hearing on the state's motion to determine whether counsel had a conflict of interest is only permissible if the trial court violated its duty to inquire and the appellate record does not show whether counsel had a potential conflict or an actual conflict. If a post conviction hearing shows that counsel had an actual conflict in such a case, the defendant's conviction must still be reversed regardless of whether the conflict adversely affected counsel's performance. A remand for a post-conviction hearing is not necessary here because the record already shows that Mulder had an actual conflict of interest. The test for an actual conflict is whether Mulder owed a duty of loyalty or confidentiality to Darin that was inherently opposed to his duty of loyalty to appellant. Mulder had an actual conflict because there was a plausible alternative defensive strategy that he could not have pursued in appellant's case without violating his duty of loyalty and confidentiality to her husband, who was a suspect, a prosecution witness, and a former client in a substantially related case. That conflict existed regardless of whether Mulder actually failed to pursue the alternative strategy because he owed a duty to Darin, or whether his performance was adversely affected by his failure to use that strategy. A defense that shifted all of the blame for the murder of both children and the cover-up to Darin Routier was a very plausible alternative to the unknown intruder defense that Mulder used. There was substantial circumstantial evidence in the record to support that alternative defense, and no credible evidence which disproved it beyond a reasonable doubt. Darin had a stronger motive than appellant. He had the means, and he had the opportunity to commit the crime. The fact that Darin was not harmed and appellant had nearly fatal knife wounds that could not have been self-inflicted in the opinion of a renowned forensic pathologist strongly incriminated Darin. Darin could have carried the sock with the blood of both boys on it to the alley without shedding any blood because he was not wounded. Darin could have cut the window screen in the garage with the knife from the wooden block on the kitchen counter. Darin's demeanor after the crime was much more incriminating than the disputed evidence of appellant's failure to express sufficient grief about the murder of their children at the hospital. Darin's claim that he slept through the murder by of his two children and was awakened by the sound of a wine glass breaking was at least as problematic as appellant's claim of traumatic amnesia. Appellant's failure to recognize that her husband was the faceless intruder who attacked her in a dark room when she was asleep might have presented an obstacle to a defense that shifted all of the blame to Darin, but it was not insurmountable, and she does not have to, quote, show that the defense necessarily would have been successful if it had been used, unquote. A defense which shifted part of the blame to Darin Routier was also a plausible alternative to blaming the unknown intruder because there would have been no evidence of the roles that the appellant and Darin played in the crime. The state had to prove that appellant actually caused Damon's death because she was not tried for the murder of Devon and the jury was not instructed to apply the law of parties. Appellant's presence at the scene of the crime was someone who had the means and the opportunity to murder both children, and even any involvement in the cover-up would not have been sufficient to convict her of Damon as a party. Mulder could not have used a defense that accused Darin of participating in the murder of his children, allowing his wife to take all of the blame and committing perjury without violating his duty of loyalty to him. Quote, an attorney who cross-examines a former client inherently encounters divided loyalties, unquote. The fact that counsel's former client was an important prosecution witness is alone sufficient to create an actual conflict, even if there was no relationship between his former client's case and the defendant's case. Mulder's conflict was especially severe because Darin Routier was a suspect as well as an important prosecution witness, and Mulder represented him in a case that was substantially related to appellants. The consistencies between Darin Routier's trial testimony and the defense that Mulder used did not remove the inherent conflict between Mulder's duties of loyalty to Darin and the appellant. Appellant was entitled to counsel who could decide whether to accuse Darin or embrace his story without considering Darin's interests. Mulder's selection of a defense that was consistent with Darin's testimony was tainted by his conflict, even if Mulder reasonably believed that he made the best choice for the appellant. A post-conviction hearing could not remove the taint because, quote, after the fact testimony by a lawyer who was precluded by a conflict of interest from pursuing a strategy or tactic that is not helpful, unquote. Mulder's duty of confidentiality to Darin was also inherently in conflict with his duty to defend appellant. It must be presumed that Mulder acquired some confidential information from Darin about her case because he needed that information to properly defend Darin against the charge of violating the gag order. Darin Routier had extensive personal knowledge of appellant's case, and the gag order prohibited him from discussing any aspect of it with the news media. Darin could have divulged confidential information about appellant's case to Mulder, in spite of the fact that Darin did not discuss the facts of the case on the tape recording of the talk show. Darin could have been held in contempt for making a statement about the case that was not broadcast because the gag order was not limited to statements that were actually disseminated by the news media. The prosecutor and the police apparently had a good reason to believe that Darin made a statement about the facts of the case to the talk show host that was not on the tape because they angrily complained to a newspaper that he directly violated the gag order. Mulder could not have known whether there was a basis for that accusation without asking Darin whether he made a statement about the facts of the case that was not recorded on the tape. Mulder also needed to question Darin about his knowledge of appellant's case to advise him about whether to testify at the show cause hearing. Mulder could not have known whether Darin would incriminate himself or destroy his credibility as a witness at appellant's trial by testifying at the hearing without asking him what he knew about her case. Darin may also have volunteered confidential information about appellant's case to Mulder because he was concerned that he would incriminate himself or hurt her defense if he was questioned about it at the show cause hearing. The brevity of Mulder's representation of Darin Routier did not substantially reduce the likelihood that he obtained confidential information from Darin about appellant's case. Mulder had a very strong incentive to carefully question Darin about his knowledge of appellant's case in the short time that they had to discuss the matter before the show cause hearing, because Darin's testimony at the hearing could have had profound consequences for him and appellant. It would not have taken Darin 5 minutes to disclose facts to Mulder that could have freed appellant and put him in the dock. Mulder had a continuing duty to maintain the confidentiality of any privileged statement that Darin made to him after their brief attorney-client relationship ended. The fact that Mulder was assisted by other attorneys who did not have a conflict did not make his actual conflict of interest harmless. Mulder had to decide whether to use a defense that accused Darin because he was appellant's lead counsel. None of her other lawyers necessarily knew whether Mulder obtained confidential information from Darin that would have helped her and incriminated him. Okay, boy, there was a lot of information here. All right, so essentially, again, just kind of rehashing some things. The trial court, they should have known about this potential conflict of interest or at least held the second hearing on it. And the big deal is that, at least in this appeal, is that Mulder did have this actual conflict of interest because he had represented Darin, and Darin at this point was both a suspect and a witness in the case. And that what this caused was that Mulder couldn't really pursue a really good defense strategy for Darlie that in essence blamed Darin for the crime without violating his duty of loyalty to Darin. So, yeah, there's a whole lot going on here, right? There was enough evidence to make a defense that would blame Darin, that would make it very plausible. But Mulder, he wasn't able to use this as a strategy because of this conflict. Even if Mulder did get confidential information from Darin about Darlie and about this whole case, he was required to keep this confidential, which conflicted with his duty to defend Darlie. And just the fact that other attorneys are present without conflicts doesn't take away the fact that Mulder still has this conflict of interest. Now, there is a citation here. It's citation number 12, if you're interested, if you go to this document. And here's what it says. Appellant's written statement and testimony left an opportunity for Darin to break the wine glass as he was walking from the Roman room to the kitchen, leave the murder weapon on the floor in the utility room, enter the garage, and then reach the bedroom on the second floor without being seen by appellant again. When appellant turned on the lights, picked up the murder weapon, and returned to the Roman room where she and the boys were stabbed, Darin could have slipped back into the kitchen, realized that the knife was not on the floor where he dropped it, raced back upstairs to the bedroom, and hope that his wife finally succumbed to her wounds. And there is a further citation in this area of the document, and that is citation number 13. And it says, a defense that shifted at least part of the blame to Darin would have been particularly convincing because it explained the facts which created the most doubt about the state's theory that appellant murdered her children and staged the cover-up by herself. Darin could have inflicted knife wounds on appellant that she could not have caused herself and carried the sock with the blood of both children on it to the alley without leaving any blood outside of the house to create the false impression that an intruder tried to kill everyone who was in the living room. So next, we move on to appellant did not waive her right to conflict-free representation. Appellant did not waive her right to conflict-free representation. The right to conflict-free counsel may be waived, but in order to be effective, the record must show the waiver was done voluntarily and intelligently. The state has the burden of proving a waiver with clear and convincing evidence, and the defendant is entitled to the benefit of every reasonable presumption against a waiver. For the waiver of a conflict to be effective under the high standard, the record must show the defendant was aware of counsel's conflict understood the consequences of continuing with such counsel, and knew that she had the right to obtain other counsel. The record in this case does not establish any of the elements of a valid waiver, regardless of whether the uncertified English translation of Halsey's stenographic notes of the proceedings on the morning of October 21st, 1996, can be considered as part of it. The uncertified part of the record only shows that appellant was willing to waive the potential conflict which existed because of Mulder's representation of her mother, Darlie Key. She did not waive or even discuss her right to object to the separate and far more serious actual conflict which existed because of Mulder's representation of her husband on that date. The references to a prior waiver of the conflict that arose from Mulder's representation of Darin Routier, which were made by appellant and her attorneys on November 12th and 18th, 1996, after the state raised the issue, did not show that there was a valid prospective waiver of any objection to that conflict on October 21st, 1996. Appellant and her attorneys stated on November 12th and 18th that they believed that she waived the conflict on October 21st, 1996, but their statements do, quote, not give a full enough picture of the proceedings on October 21st to allow us to determine whether the waiver was knowingly and intelligently made, unquote, on that date. Furthermore, a knowing and intelligent waiver of the conflict on October 21st would not have waived appellant's right to object to it on November 12th when the state disclosed new circumstantial evidence of Darin's involvement in the capital murder, unless she prospectively waived her right to raise the issue again if new evidence emerged. There is absolutely nothing in the record to indicate that appellant was aware of the consequences of Mulder's conflict when she expressed a willingness to waive her objection to it on November 12th and 18th, 1996. This court cannot presume that Mulder privately advised appellant about the consequences of his continuing duties of loyalty and confidentiality to her husband. It is very unlikely that appellant knew without being told that she was entitled to different and even court-appointed counsel because Mulder had an actual conflict of interest. It would have been reasonable for appellant to assume that she waived her right to court-appointed counsel when she discharged them and retained Mulder. Appellant had no money of her own to hire a different lawyer if Mulder was discharged because of his conflict. There was no evidence that her family could afford to retain another attorney to represent her at a capital trial that was likely to last 6 to 8 weeks after they paid for the services of, quote, one of the most successful lawyers in the state of Texas, unquote. Appellant also did not know whether the trial court would give another lawyer any time to prepare her defense if her family was able to retain one for her. In short, appellant's conviction must be reversed and a new trial must be ordered because her lead counsel had an actual conflict of interest, and the trial court did not conduct a hearing to determine whether she was aware of the conflict, whether she understood all of its consequences, and whether she wanted a different attorney to represent her. And this is the last portion of the appeal of the point of error number 1. We still have plenty more to go, but let's go ahead and discuss what was talked about in this one. Essentially, it's saying that Darlie's choice to go ahead and retain Mulder as her attorney must have been done voluntarily and intelligently, and that she completely understood the consequences. However, the thing is that the record doesn't show that she essentially properly waived her right regarding this conflict of interest involving her attorney Mulder. There are some references made to a prior waiver made later in the proceedings. I don't know where this occurred. Even if there was, it wouldn't necessarily apply to later proceedings. And there's actually no evidence that Darlie even understood the consequences of continuing on with Mulder as her attorney. And it's also unknown if she even knew that she could get a different, potentially court-appointed attorney because of this conflict. She had financial constraints if she had to hire a brand new attorney, not a court-appointed one. And there were obviously concerns, because here the trial here comes Mulder on the day, the day that the jury is being selected. And I mean, what time does this actually give her to find another lawyer if she wants one? So, anyway, that's it for point number one, the point of error number one. A point of error number two will be in the next episode. And I really hope that this is of some interest to some of you out there. Maybe not all of you. I know it's a lot, right? It's a lot of really legalese, a lot of legalese. And I'm trying to do my best to kind of put it into plain language. So I hope that that is helping at least a little bit. I really debated whether or not to go ahead and do the full appeal, but there were some things in here that I wasn't even aware of, that didn't come up in trial, that I mean, I don't know at the time if the public was aware of it, but, definitely some really interesting things in here that I thought that you also might be interested in. So I hope that you do find them of interest. This is gonna run quite a few episodes. Hopefully, I'm gonna try and make this as short as possible so we can continue on with other things, regarding the trial. But nonetheless, thank you all for listening. I appreciate each and every one of you. I hope you understand that. I really do, because this is a lot to listen to. If you haven't yet, please subscribe, click that bell so you're notified of new episodes if you're on YouTube or listening or watching this on YouTube. And until next time, I will talk to you soon. Bye for now.